The Supreme Court has agreed to hear arguments in the case of a former mail carrier with the United States Postal Service who says he was forced out of his job because his work schedule conflicted with his religious obligations. Gerald Groff is an evangelical Christian who says his Sunday work shifts hindered his ability to practice his religion. USPS initially offered him to work on other days, but a new partnership with Amazon moved his schedule to Sundays. Groff's attorneys believe that the Postal Service should have accommodated his request so he didn't have to quit his job. Post Office officials have not released a statement about the ongoing litigation. Joining us now to take a deeper look at Groff's case is senior counsel with First Liberty Institute, Stephanie Taub. Good morning, and thank you for joining us.
Good morning. Thank you for having me on to talk about this very important case for religious liberty.
So the First Amendment reads, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. I'm guessing that second part, abridging the free exercise thereof, is the issue that the client here has, Mr. Groff. Is that correct?
Well, we are actually asking the court to reinterpret to interpret the law as it is written. We're talking about a federal statute, federal civil rights statute from the 1972. And so we're asking the court to protect religious liberty in the workplace. And this case has the potential to protect employees of faith across the country. For too long, courts have favored big government employers and corporations at the expense of the religious liberty of religious employees who simply want to remain faithful to their God or to their religious beliefs.
In this case, what I read was that Mr. Groff was accommodated by the Postal Service for 2 years. They just had other people cover his Sunday shifts. He even moved to a different post office where they weren't delivering mail on Sundays for Amazon. And then the Postal Service stopped. They said, we don't have enough people to cover your shifts. You have to come to work. And he declined. So my question is, the individual rights of religion versus a business's ability to function, and in this case, the Postal Service, is the business just supposed to not function on Sundays because this man can't come to work because of his religious obligations?
Absolutely not. We're asking the court to accommodate when they can. So that's the problem here, is the law as it's written provides that big businesses, big corporations are supposed to provide these reasonable religious accommodations unless it would cause undue hardship to the business. But the problem is the court hasn't really taken that robust standard seriously, and they've gutted religious protections. So employers like the post office could provide that accommodation, but the problem is they're not willing to make that effort. And we've seen this across the board so many times. These employers are perfectly capable of making this religious accommodation. They just simply don't want to. And so we're asking
and the post office did say, though, that they could not continue to make the religious accommodation, that they didn't have enough people to cover the Sunday shift.
Well, that's not exactly true. They accommodated him and are absolutely able to accommodate him. Mr. Groff was able to work, was offering to work extra shifts. He was offering to transfer to a different post. He was offering to work non-Sunday holidays. So there were many opportunities, but the problem is post office didn't believe that they had to they didn't have to accommodate him. And so the real question is here, we need to return to the proper standard. And this is a standard that's common in employment discrimination law. In every other civil rights statute that protects employees, this standard means something that's actually strong, that's actually real, that's actually meaningful. But when it comes to religious employees, the courts have gutted those religious liberty protections. And so now is the opportunity for the Supreme Court to really restore religious liberty in the workplace.
Now, I don't want to pry into Mr. Groff's personal life, but I do feel like the justices are going to ask how you define work and doing work on the Sabbath. Is it just going to work at the Postal Service? Because I know in some, for example, Orthodox Jews, they don't flip light switches on the Sabbath. They don't cook meals. Is Mr. Groff sitting at home not doing anything on Sundays, or is he just not going into work at the Postal Service?
Well, he is a traditional Christian who believes in observing the Sunday Sabbath and not working on Sundays. And many people have similar beliefs. And so the real question here is, what is the proper standard for the courts to apply? What's the proper standard to hold big businesses and big corporations to? If they have the ability to accommodate without undue hardship, they should provide those accommodations. People like Gerald Groff are simply wanting to remain faithful to their God, faithful to their religious tenets. And here, we're asking the court to apply the law really as it is written and provide these meaningful religious accommodations.
Has the court set a date yet for when this hearing will take place, or when this case will be argued?
We're anticipating it later in the spring, and probably will receive a decision around June.
That is very interesting. That's Stephanie Taub. She's an attorney for religious liberty, and we're talking about USPS lawsuit and freedom of religion. Thank you for joining us.
Thank you for watching. Go to newsnationnow.com to find NewsNation on your television provider. And don't forget to click the red subscribe button below to get more of NewsNation's fact-driven, unbiased coverage.